ઓબીસી બીએ વાડોદરિયા
ભાઈ બીએ વાળોદરિયા
ભરત લાખાભાઈ
ભરત લાખાભાઈ
રોટી પીજે બધી બોલાવ સામે વાળે કે અરજ કરે કે કોઈ
આ કાઢી જ નાખવા છે એસઆઈ કુરેશી
ઓબીસી એસઆઈ કુરેશી
ભાઈ એસઆઈ કુરેશી
હર્ષિતાબેન દિલીપભાઈ હે
ભાઈ
મની
બેન
कौन जी आपकी दो क्या
રિપોર્ટ
आप
એકદમ સનાને મુદત રિપોર્ટ ઓબીસી જીપી ગોહિલ
ભાઈ જીપી ગોહિલ
ઓબીસી એસજી શ્રીવાસ્તવ
ભાઈ એસપી શ્રીવાસ્તવ
અશોક કુમાર પુરુષોત્તમ દાસ
અશોક કુમાર પુરુષોત્તમ દાસ
मैं बोल रहा हूं अरे अशोक कुमार आज
अब सरकार ने आके दिला पैसे
अशोक कुमार पुरुषोत्तम दास
એમને વકીલ નથી આવતા
વકીલ નથી આવતો
તમારા વકીલ નથી આવતા
વકીલ પાસ કરે તો થાય તો
ક્યાં?
બધા પર કેસે તે ગાડી લેજો પડે
વકીલ નો આવવાનો હોય તો અરજી લખાઈ લો
वकीलों ने अर्जी लेता हो ओबीसी सीके नथवाणी
ભાઈ સીકે નથવાણી
रमेश चंद्र चिमनलाल
રવિચંદ્ર ચિમનલાલ
એમપી ઘડિયા
जेपी गढ़िया
ભાઈ એસપી ગાડિયા
रविराज सिंह कनुभा
રવિરાજ કનુભા
ओबीसी एमएम कुबावत
ભાઈ જેમે કુમાર
नवीन चंद्र हंसराज
રવિચંદ્ર હંસરાજ
ओबीसी जेम नाखवा
ભાઈ જેમ નાખવા
ओबीसी बीएन व्यास
ભાઈ જેમ વ્યાસ
पूर्वी बेन दयानजी भाई
પૂર્વીબેન નયનજીભાઈ
श्वेता बेन हार्दिक भाई
શ્રીનાબેન હાર્દિકભાઈ
ओबीसी एवी राठौड़
ભાઈ એવી રાઠોડ
ओबीसी बीएल झाला
ભાઈ જીએ ઝાલા
9 ने 10 कनेक्टेड दिनेश चकुभाई
દિનેશ ચકુભાઈ
हितेश केशवलाल
હિતેશ કેશવલાલ
रामजी भाई विजसुर भाई
રામજીભાઈ વિષ્ણુભાઈ
આરોપી દિનેશ ચકુભાઈ
दिनेश भाई कौन है तमे
ચલાવવાની છે
बीएल झाला
સાંભળી લો એજી લખાણી
ओबीसी एजी लाखाणी
ભાઈ જેજી લાખાણી
नजीमा बेन इकबाल भाई
નજીમાબેન ઇસ્લામભાઈ
अजहर कादर
અઝર કાદર
ओबीसी आगे वागेला
ભાઈ જાગે વાગેલા
12 અને 13 સિરિયલ નંબર અભિપ્રાય બાકી છે વિવય જાની
ભાઈ વિવાય જાણી
સિરિયલ નંબર 14 ધ્યાન जाला એમણે સિરિયલ નંબર 15 ઓબીસી જેએસ રાઠોડ
ભાઈ જે રાઠોડ
નોટિસ બજી ગઈ એમાં તમે વાળી રેહાના શેજાદ
રેહાના તેજાદ
ડોમેસ્ટિક નો ડિલે બજી ગઈ રેહાના શેજાદ કરી સિરિયલ નંબર 17 ઓબીસી એએન મહેતા
ભાઈ બેન મહેતા
ટીએસટી નો કેબિનેટ सिरियल नंबर 19 ओबीसी आई पिठोड़िया
ભાઈ આયા પીઠડિયા
चतुर सिंह खुशाल सिंह
ચતુરસિંહ કુસાજી
सीरियल नंबर 22 की जीएसटी की बीजी था बाकी रिवीजन ओबीसी जोशी
ભાઈ જે જોશી
मुझे रिपोर्ट है जो थी कंटिन्यूअस के सिग्नल के निशान है
चलो
तो ट्रांस
ये हम अच्छे बार में पाइप है
ले लो
हाँ
रणछोड़ भाई जीवा भाई
रणछोड़ भाई जीवा भाई
पंचोतेर 16 હશે ને એટલે પાછું જોવું પડશે બે સામ સામે 3 અને 59 4 16 તારીખ 16/3
रणछोड़ भाई हाजिर बता दे महेश भाई यस नरेश भाई विपुल भाई नीमू बेन नीता बेन रसिक भाई 16/3 जाओ પછી ધીરુભાઈ જગનભાઈ બોલાવ કરો ધીરુભાઈ જગનભાઈ
ધીરુભાઈ જગનભાઈ
એમાં 16 ની ક્રોસ છે
હા ક્રોસ આ એમાં 9 નંબર એકદમ સંજય ये धीरुभाई આવી જાઓ ફટાફટ બોલે
આયો છે
આયો કેસ કરી દો જી મારા ધીરુભાઈ जयंती भाई भाणजी भाई कौन है भाणजी भाई राजेश भाई सुरेश भाई प्रवीण भाई बाबू भाई सविता भाई 16/3 जाओ 16/3 वकील श्री ए समा
वकील श्री ए समा
वकील श्री के धोળકિયા
वकील श्री के धोળકિયા
कुमारजी धनुबा आजा दिया
તમારો બીજો સેક્શન છે
हां एक वाला कंटिन्यू है
એ તો ડિસ્કસ કરવાનું
ना एमा अर्धी નથી अर्धी નથી
ભૂલી ગયેલા બીજા પણ સમજ કરે
ના એને આનું કીધું હું અડધી આપી દઉં છું પછી કે તમને કહો કોઈ અડધી બધી ભૂલી ગઈ
એને ડિસ્કાર્ડ કરવાની વાત કરી
અડધી દેવાની
બેસણ
कुमारसिंह विष्णुसिंह विजय भाई टीतू भाई यजुवेंद्र सिंह अकबर भाई
બેસણ
कैसो बात
એને કીધું કે ડિસ્કાર્ડ કરવું જોઈએ નથી બોલવાનું પછી સૌથી છેલ્લે
हां
એપી આશર
वकील के पीएम मीरानी
वकील श्री ए मीरानी
वकील एम मनोरकर
वकील श्री ए मनोरकर
एसपी ध्रुव
वकील श्री ध्रुव
जुनेद रजाक वगैरह जुनेद रजाक
वगैरह
एक नो रिपोर्ट कयम भाई मोहसिन भाई असलम भाई प्रदीप भाई अय्याज भाई चार ने बात में कौन है यूके डीएम वीरानी
वकील श्री ए मीरानी
ये दिया सर बात में कैसे ना भी चार में डीएम वीरानी माइक से आजे आयो चल बेसो बाहर बेसो इधर बेसो
હા એને આવશે કરવાની સરકારની વાત
आरो भी एकदम संजय ना
તારીખ જ નથી રૂપિયા આવે તો પૂછીને જઈ શકે છે તારીખ નથી એ કંપનીને આપી દો 20
वकील से भी सोमया
वकील श्री ए सोमया
आरोपी ने एकदम संजय नो क्रॉस मैटर नो आरोपी બહાદુરભાઈ બાલાભાઈ
બહાદુરભાઈ કાલાભાઈ.
તેલ નંબર 32 ઓકે સીએમ યુસુફ છે તૈયાર હો તમારો
એમ જુગાની ચાલુ છે ને
હા આગળ બહાદુર બાલા છે
બહાદુરભાઈ કાલાભાઈ.
આવે બાકી સાવ તૈયાર હો તમારે લેવાનું
સુભાષભાઈ ભગવાનજીભાઈ
સુભાષ ભગવાનજી
સુભાષ ભગવાનજી.
ભગત ડીએસ ત્રિવેદી
ભગીરથ ત્રિવેદી.
એ જે વકીલે બોલી ગયો ભગત જોશી
ભગીરથ જોશી.
કે બી સર સુભાષભાઈ તમારા વકીલે બોલાઈ ગયો 1 થી 4 અને 6 નો રિપોર્ટ છે 5 નંબર મુકેશભાઈ નો બોલાવતો ને મુકેશ નરસિંહભાઈ
મુકેશ નરસિંહભાઈ.
એનો રિપોર્ટ એનો રિપોર્ટ છે એક સેકન્ડ
આજે શું તકલીફ હતી બધા બાર પણ નથી.
12 ભગત જોશી એજાજ અનવર
એજાજ અનવર.
2 નંબરનો રિપોર્ટ 2 નંબરનો રિપોર્ટ
બાકીના
એ હાજર છે હાજર એમાં સરળ હતા એમાં કેવું તો જો લખવાનું હતું કીધું ને ડીવીડી બધું હાજર છે
કમી નથી
એજાજભાઈ 2 નો રિપોર્ટ પછી હનીફભાઈ નિલેશભાઈ 212 ભગત એમી સોમૈયા જામનગર જિલ્લા પૃથ્વીરાજસિંહ પીએસઆઈ ડીડી લાડુમોર
પીએસઆઈ ડીડી લાડુમોર.
બેસો બાકી ભગત જગદાણી
ભગીરથ કાકાણી.
બસીર અનવર એકદમ સર બીપી કે બીપી ક્લોઝિંગ આપી દેવાના નામ
પીપી સેરો મારે તારીખ નથી પીપી સેરો મારે પીપી
હા
પછી તારીખ એને રિકોલ કરી દે તારીખ નથી બારની
12 તારીખ
જી કોંગ્રેસ.
બહાદુરથી બાલાભાઈ આવી ગયા બહાદુર બાલા
બહાદુરથી બાલાભાઈ.
તેલમાં 37 બાકી
કાલે જોવું અંદર માટે
હા આ દીકરી પણ
ખ્યાલ બરોબર ટીટીપી કાલે સરાવી દઈશ
અહમદ પુંજા
આમદ પૂજા.
પછી પીએમ છે
હા.
ચાર નંબર 5 એકદમ રાખવાનું છે મોબાઈલ અહમદભાઈ મુસ્તાકભાઈ અબ્દુલ કાદર કાસમભાઈ સાક્ષીના બોલર કરો શાહનવાઝ હાજી
શાહનવાઝ હાજી.
અંદર જ નથી સાહેબ છે
ક્યાં છે દોશી મામદ
દોશી મોહમ્મદ.
આરોપી
તારા છે.
16 નામ
આ કોણ છે આરોપી કે સાક્ષી
એક પણ સાક્ષી હતો દોશી મામદ આરોપી છે ને હા 40 નંબર ઉપર પણ શાહનવાજ વિટનેસ માંથી ખાલી પછી પીએસઆઈ કે રાતિયા
કે રાતિયા
તોસીમ ₹10
કોસી મોહમ્મદ વાળા આવી ગયા ને બધા જરીના બેન સફીના બેન આમાં દોસ્ત મોહમ્મદ
છે.
અને મુનાફભાઈ બેસો ये नंबर 38 जोकसी एसकी दाऊदिया
દાઉદિયા
जितेंद्र सिंह विरसी जितेंद्र सिंह અને વીરસી
રિપોર્ટ આવે છે ઓપરેશન કરતી આવે
વૈશાલી બા
ગઈ તારીખ હાજર તમાર
તમે આવો ઈ બસ એક ને એક રિપોર્ટ આવે ચૌદ ત્રણ જાઓ 14
હા
બીસી ચોટાઈ
બાકી છે બીજી જોટાય
મુક્તાબેન મુકેશભાઈ
મુકેશભાઈ
કિમજીભાઈ બાવાભાઈ કિમજી બાવા
લાવે
કિમજીભાઈ એક નંબર એકદમ સરસ 21 જાઓ 21 ભગત એની કંજરિયા
બાકી છે એની કચરિયા
જામનગર જેલ તારીફભાઈ તારીફભાઈ પંચોના પલોટ કરો જગદીશ જેઠાભાઈ
જેઠાભાઈ
કેન્તીભાઈ બોલાભાઈ
બોલાભાઈ
કેન્તીભાઈ જગદીશભાઈ નથી જગદીશભાઈ છે પછી ધનજીભાઈ જીવણભાઈ ધનજીભાઈ હાજર અલ્તાફભાઈ હાજર બેસી જાઓ બધા ભગત એની કંજરિયા
બાકી છે એની કચરિયા
કાળભાઈ બેસાડી દો જામનગર જેલ તારીફભાઈને બેસાડી દો એમડી સોમૈયા ગજેન્દ્રસિંહ જામનગર જેલ જાતી ગઈ થોડી જામનગર જેલ ગજેન્દ્રસિંહ માં 7-3
જી સર
ચાલી ઓકે ત્યાર કે રાઠોડ
બાકી છે રાઠોડ
અનુભા ગંભીરસિંહ
છે
બે નંબર એક જુનિયર માટે કાંતાબેન ગંભીરભાઈ
કાંતાબેન ગંભીરભાઈ
જામનગર જેલ
સર
હા એક આરોપી છે ભરત ગંભીરભાઈ પરમાર તમારી જેલમાં છે કે તપાસ કરજો
સર એ છે જેલમાં પણ આજે એમને જેએમએફસી કોર્ટ કાલાવડ ખાતે રૂબરૂ મોકલેલા છે ચોરીના ગુનાના કારણે
જામનગર જેલમાં જ છે
આ છે જેલમાં જ પણ આજે એમને કાલાવડ કોર્ટમાં રૂબરૂ મોકલેલા છે
અનુભા અનુભા કોણ છે
ના
કાંતાબેન
બધા તો પછી ગયું બપોર પછી ત્યાંથી કાલાવડ થી લાવે તો 1000 જણાનું કર્યું બેસાડવા લોકો
તમે લોકો બહાર બેસો કાલાવડ ત્યારે બે જઈને બહુ પછી એને હાજર કરાવી દેજો
જી સર.
હા 3 વાગે હાજર કરો પગથિયે બી સોમૈયા ભરતભાઈ નારણભાઈ કે આરો બિલ તમારા આવવાના છે રિપોર્ટ આપી દેજો પ્રવીણભાઈ ભીમજીભાઈ પંચનો બોલાવ કરો પ્રવીણભાઈ ભીમજીભાઈ ધર્મેન્દ્ર કરશનભાઈ
અશોક હરિભાઈ
અશોકભાઈ જામનગર જેલ
ઓકે અશોક હરિભાઈ
અશોકભાઈ વકીલ કોણ છે તમારા
વકીલ કોણ છે સર? એમનું ફોર્મ લીગલમાં મોકલાવેલું છે.
લીગલ મોકલી દીધું છે ને એ બી સોમૈયા અશોકભાઈ હરિભાઈ નું ફોર્મ મોકલેલું છે 12/24 તપાસ કરી ગીટી ફાઇલ કરી દેજો 13/12/24 અશોકભાઈ હરિભાઈ નામ છે
અમે ડી મંગાવ્યા ટિફિન કહી દો તો કોઈ પણ સામે ચાર્જર મૂકી
ચાર મોકલી
અને આને કોણ ઘણા લોકો પછી ડોક્ટરને બોલાવ્યું ડોક્ટર
બહુ બધી હા જામનગર જેલ
જી સર.
5 વાગે ડોક્ટરને જરા હાજર રાખજો
ડોક્ટરને 5 વાગે સાહેબ રૂબરૂમાં કે વીસીમાં?
નહીં વીસીમાં
વીસી થી હાજર રાખજો 5 વાગે ડોક્ટરને
જી સર.
ઓકે અત્યારે એમને જવા દે
તારીખ આપી દો
7/3 માં અશોકભાઈ
જી સર.
અર્જુનજી
મોરારજી ઠાકોર
હાજર છે.
વકીલ કર્યા તમે
વકીલ નો ફોન કર્યો તો મેડમ.
તમે કરવાના છો અહીંથી આપીએ તમને
પ્રાઇવેટ રોકવા છે સરકારી આપી દે? પ્રાઇવેટ રોકવાના સર એમને.
ક્યારે કરશો વકીલ હવે વકીલ કરી લેજો હવે
વકીલ તમે કરી લેજો આવતી મુદતે કેસ તમારો ચાલવા મળશે 11/3
જી સર.
કમાભાઈ ધનાભાઈ
છે
કમાભાઈ હાજર બેસો
ભાઈના માંડવા છે પોતાનું એના ભાઈના માંડવા છે પરિવાર મળે
પીપી આવે એના પેલા બધા નોટિસ થઈ જાય તો લઈ લો દીપકભાઈ
બીઆર ત્રિવેદીનો કોલ કરો
આયા લઈ લો એનો
આવી જાઓ.
501 બધાના જ એડ્રેસ લઈ લો પીપી આવે ત્યાં સુધી
521 છે અને
આનો છે ને જોડાણી ભાઈને જરાક બોલાવો
એ કે ભરવાના ફોલ્ડર માં છે હવે લઈ લો
since 2022. Going on since 2022, so it's virtually over. After completion of investigation, only my client came to be arrested. But formal complaint, they normally file on the last moment, 57, 58 day. Well, what's the other? This is the tax dispute. I understand different from the scams. Day in and day out. In the newspapers, we come across 1,000 crore scam, 2,000 crore scam. Wherein, what happens is that the accused obtains Aadhaar card, photograph, PAN card of poor people, underprivileged people, float, sell companies, do bogus billing, and government is duped of crores of rupees. This is not that case. Here, the father as well as son. Father is in business since last 25 years. Son has recently joined the business. But they are in business since long. A reputed person in the society, reputed person in the market. So different from those scams. The date of arrest is 2nd of February 2024. So almost since last 25, 26 days he is in custody. So the charges are under section 132 subsection 1 clause C. But today I have tendered one compilation. My lords may be having that compilation running into 173 pages. There I have placed on record the relevant provisions. There, for a moment, my lords may please see page 17, section 132. Under GST, this is the only section wherein one can be booked. But if I may read, punishment for certain offences. Whoever commits any of the following offences. Now I'm booked under clause C. Avails input tax credit using such invoice or bill referred to in clause B. So one will have to refer to clause B also to get a clear idea. Clause B is issues any invoice or bill without supply of goods or services or both in violation of the provisions of this act or rules made thereunder, leading to wrongful availment or utilization of input tax credit or refund of tax. And C is availing input tax credit using such invoice or bill referred to in clause B. But clause B says, I'm sorry, clause B says that one person has not sold goods, has not supplied services, but issued only invoice. If I may read again, issues any invoice or bill without supply of goods or services. Under GST laws, if I supply goods, if I supply services, then and only then I have to issue invoice. Otherwise, it is a bogus billing activity that I cannot do. So clause B says that someone issues any invoice without goods, but I am booked under clause C. The allegation against me is that I have not purchased goods, I have purchased only invoice. That is the allegation against me. But if I may point out very briefly, I am the proprietor of Liberty Products. It is a proprietary concern registered under the GST law. So the alleged amount of evasion is 7 crore 45 lakhs. So under GST, up to 5 crores it is bailable. Once it exceeds 5 crores, it becomes non-bailable. So it is a non-bailable as of today. Under the GST, how it works, it is a value-added tax. The tax which I pay on purchases, that I get as a set-off against tax payable on sales. એટલે ખરીદી ઉપર સાહેબ મેં જે વેરો ભરેલો હોય એ વેચાણ ઉપર જે મારે ભરવાનો છે એની સામે મને બાદ મળે, which is called input tax credit. Input tax credit I can avail only when I have purchased goods. The allegation clause C is I have not purchased goods, I have purchased only invoice and claimed input tax credit of 7 crore 45. That is sub clause C. If I may point out salient provisions, please have page 2 of my compilation. The offense is under section 132, but the power to arrest flows from section 69. But I have highlighted, I may not read, where the commissioner has reasons to believe. The word used is reasons to believe, not reasons to suspect. There is a vast difference between reasons to believe and reasons to suspect. Here, what happens only on the basis of suspicion, people are arrested. That I'll demonstrate, because until and unless there is adjudication, until and unless there is a determination of tax, there is assessment. Not everything runs on suspicion. Today, there is no adjudication, no assessment as of today. Clause 70 is the power to summons. Now, kindly see page 3. So this is what I'm trying to point out. But under the GST, take a case that I am booked, I am arrested, my bail is denied, I am put on trial, but I am even sentenced to maximum imprisonment of 5 years. Still, the government revenue would not be in a position to recover a single penny without there being any determination. Determination is must. So section 73 and 74 talks about determination. 73 deals with non-fraud cases and page 4 is section 74, which is for fraud cases. Either I have to be assessed under 73 or 74. If the department alleges fraud, then I can be assessed under 74, otherwise under 73. The difference is penalty. 73 only 10% penalty, 74 100% penalty. So until and unless the tax is determined, recovery is not possible. I cannot file appeal. I cannot go for compounding as well. Until and unless there is determination, everything proceeds on reasons to suspect, not on reasons to believe. That is my respectful submission. But after 73 and 74, please have a look at page 7, section 78. But there are powers to recover. Within 90 days, I get 90 days to file an appeal. If I don't file appeal, if I don't obtain stay, then as per section 78, they can recover. How to recover? Below section 79, they can attach my bank account, stock, properties, as if it is an arrears of land revenue. Thereafter, please have a look at page 11. Section 107. But within 90 days, I can prefer first appeal before commissioner appeals. If I am aggrieved by the order of 73 or 74, I can file first appeal. But please have a look at section 6. But in appeal, I have to pay only 10% of tax. This is very relevant because that amount I have already paid without there being any determination. So kindly see clause A. Admitted tax I have to pay in full. Clause B would be relevant. A sum equal to 10% of the remaining amount of tax in dispute arising from the said order in relation to which the appeal has been filed. And subsection 7, if I pay that amount, the recovery for the balance amount shall be deemed to be stayed. Once the adjudication happens, within 90 days, I can file first appeal. In first appeal, I have to pay only 10% of tax, no interest, no penalty. And once I pay 10%, remaining amount is deemed to be stayed. Thereafter, page 40, section 112. If I fail in appeal, then before the tribunal, I can file second appeal. And thereafter, even if I fail before the tribunal, and if there is a question of law involved, I can file tax appeal before the Honorable High Court, and thereafter SLP before the Supreme Court. But so far as fact finding is concerned, tribunal is the last authority. So close page 17, I already pointed out, section 132. Allegation, I'm sorry, what I'm trying to point out is clause C is availing input tax credit only on the basis of invoice, no goods. Page 17. Clause C talks about that. But the case of the department is not that I have received only invoice. But I'm booked under clause C. Clause C says that I have obtained only invoice, not goods. But the case of the department is not that I have obtained only invoice and not goods. Case of the department is that the supplier, I have purchased goods from 6 vendors located in Tamil Nadu and other states and one in the Gujarat itself, in Gujarat also. The case of the revenue is that those 5 or 6 vendors, they have not paid tax to the coffers of the state. I'm sorry, I could not place on record this document. Section 60, subsection 2. This is precisely the case of the department. Input tax credit, section 60. Conditions, clause subsection 2. Notwithstanding anything contained in this section, no registered person shall be entitled to the credit of any input tax in respect of any supply of goods or services or both to him unless. Now there are various conditions. Now clause C is very relevant. Subject to the provisions of section 41, tax charged in respect of such supply has been actually paid to the government either in cash or through utilization of input tax credit admissible in respect of the said supply. So the case of the department is, I have purchased goods, I have procured invoice also, but the suppliers have not paid the tax. Either the suppliers have not paid the tax or suppliers have claimed inadmissible input tax credit. That is the case of the revenue. Now, if that be so, I may not be entitled to input tax. This provision is under challenge. The constitutional validity is under challenge. The future will only tell what happens to this provision. But as of today, if the supplier has not paid tax, I am not entitled to input tax credit. They can recover, anything can happen. But I cannot be booked under 132(1)(c). Let me give an example. Take a case. I am manufacturing a product. According to me, that product is exempt from tax. So I did not collect tax, I did not pay tax. Now government says, the department says, no, your interpretation is wrong. This product is not exempt, it attracts 18%. I lose everywhere. They can recover also, but I cannot be booked under 132. Each and every, my crux of the submission is, each and every demand exceeding 5 crores would not automatically become an offense under 132. It becomes an offense under 132 only when I have procured only invoice. If I have procured invoice and goods both, but the supplier has not paid the tax, they can assess They can recover. I lose everywhere. My properties are also gone, but I cannot be arrested. That is my respectful submission. And why I am saying so, જે છ વેપારીઓ પાસેથી જે મેં માલ લીધો છે, that goods were coming from Tamil Nadu. They were intercepted near Chotila, near Mamadgor. The department themselves seized those goods, detained those goods. I had to prefer a writ petition before the Honorable Gujarat High Court, give some solvent security there, and thereafter the Honorable Gujarat High Court released my goods, my lord. That order also I have placed on record. But please have a look at page 162 for a moment of the compilation. I'm sorry, 163. Date of order is 1st July 22. Since then it is going on. Investigation going on since 22. Page 164 may please be seen. Section point para 4. This is Om Banna Enterprise. Allegation against this Om Banna and others. So the goods contention, if I may read, contention has been raised by the petitioner that goods in question were purchased from one Om Banna and the same was being transported. When the goods were in transit, the authorities intercepted the goods and confiscated them. In other words, it was submitted that the authorities sought to derive the powers to overcome the possession of the petitioner of the possession of the goods of the petitioner in transit from section 129 of the GST Act. It was submitted that since section 129 GST Act begins with non-obstant clause, it is a provision independent of section 130. It was submitted that entire exercise of powers under section 130 was without jurisdiction. Now please have a look at page 165, the operative portion. This matter is still pending, Lord, for final hearing. Matter is still pending. But the interim relief may please be seen. Page 165, para 6.3. Resultantly, by way of interim relief, the respondents are directed to release the goods and conveyance of the petitioner on condition that the petitioner deposits with the competent authority of the respondent an amount of rupees 40 lakh within 10 days. Furthermore, when the final order is passed and the order also includes determination of fine in lieu of confiscation, the petitioner shall further comply with the condition of furnishing of bond of 1.17 crores to be furnished within 10 days, along with deposit of amount of 40 lakhs. But thereafter, please have a look at page 167. This is the challan. I have paid 40 lakhs. And page 169. This is the release order. If I may read below the operative portion, I have highlighted. Namdar Gujarat High Court na SCA number so and so, तारीख so and so na oral order अन्वये પેરા નંબર 6.3 મુજબ કુલ રૂપિયા 40 લાખ રકમ ડિપોઝિટ તથા 1 કરોડ 20 લાખના બોન્ડ રજૂ કરતા વાહન અને માલ મુક્ત કરવા આદેશ કરેલ છે જે અન્વયે સોન્સ. It is not the case of the department that I have not purchased goods. Had it been that case, I would not have argued this. That case, then 132. Had it been that case that I have not purchased goods, then 132 1C would apply. It is their case that I have purchased goods. Goods were intercepted by them, detained by them, released by High Court. It is their case that the suppliers have done something wrong. Suppliers have not paid tax or suppliers have claimed ineligible input tax credit. They may be right. I may have to pay this amount today or sooner or later. But 132 1C cannot be invoked. That is my respectful submission. That is wrongly invoked against my client. After this search, after this detention of vehicle, there was a search at my premises from 25th of April to 29th of April. 5 દિવસ search. Everything was seized. Documentary evidence, electronic evidence, mobile gadgets, everything. Again, on 2nd February 2024, that is the date on which I was arrested. Again, there was a search at my residential premises. For 2 years, they did not do anything. Matter is still pending before the High Court. For 2 years, they did not do anything. One fine morning on 2nd February 2024, they again come to my residential premises. Whatever was there at my residence seized, and I'm arrested. I was remanded for 2 days to their custody. The learned chief judicial magistrate rejected my the first bail application. That is how I am before my lawsuit. Coming to the provisions again, section 132 I have read out. Please have a look at page 20 of the compilation. Section 134, tribal by magistrate. No special courts, tribal by magistrate of first class. Please have a look at page 22, section 138. It is even compoundable. It is even compoundable. And below, there was an amendment by the Finance Act of 23 at page 24. Relevant portion is at page 25. I have highlighted. So only 25% I have to pay, the offense gets compounded. Minimum, that is minimum. Maximum is 100. Earlier it was 50 to 150. 50% minimum, 100% maximum. Now it is 25 and 100. I cannot even apply for compounding today because there is no adjudication. There is no assessment. I cannot go in appeal. I cannot go in compounding. And everything proceeds on reasons to suspect. Page number 26 may also be seen. But these are the guidelines by the central government for arrest and bail. So only in extraordinary cases where I am a habitual offender, where there is scam, where I have floated fictitious funds. Look, here it is no such allegation that I have floated fictitious funds. It is not the case of the department. Those 6 funds are located elsewhere. And I will also point out how this registration is granted. Registration is not like anyone can apply and get themselves registered. There is a foolproof verification. I need to submit my Aadhaar, I need to submit my PAN. Now even biometrics is done. The proof of business, rent agreement, not the sale agreement, my ownership proofs, everything is to be submitted. Thereafter only the registration is granted. The registration is granted by Tamil Nadu government. Now department says that those registrations were fake, but they were granted by their own counterpart in Tamil. So my respectful submission here is that real culprit here are the suppliers, 6 suppliers. Please have a look at my application only straight away. Page 27. Page 25 onwards is the arrest memo. The table is at page 27. Page 25. Arrest memo starts with page 25. The table is at page 27. Kindly see the table below. All the allegation against these firms, Om Banna, registration obtained by fraud. Thereafter below, next page. Kamdhenu, taxpayer found non-functioning, not existing. Same for serial number 3, Sahani Corporation. Again for Gautam, registration obtained by means of fraud. Sandeep Trading, against registration obtained by means of fraud. And last is Tulsi. Search conducted against the said firm, they have obeyed wrongful ITC. One firm is in Gujarat, remaining are outside the state of Gujarat. So the entire case is against the suppliers. The suppliers have done something wrong. If the suppliers have done something wrong, as per section 16, subsection 2, clause C, I may not be entitled to ITC. But the case cannot be built against me under section 132, subsection 1, clause C, under which I am arrested. That is the submission. So in fact, I am also the victim. Government is duped of the revenue, I understand. But I am also victim. Government can at least recover from me. Today I am behind bars. I paid 40 lakhs. Other 10 lakh I have paid. 1 crore 20 lakh security I have given. જ્યારે ભવિષ્યમાં demand ઊભી થશે, again I will have to pay 10%, 20%. And if I fail everywhere, I will have to pay entire amount. So it is, I am also victim here. That is the respectful submission. My transactions are through banking channels. Not a single case has been found from my premises. Not a single penny unaccounted case. No recovery, discovery is pending. See, this investigation going on since 2022. But it is not the case of the department that I have not cooperated. I was very well cooperating since 2020 to this 2024. On 2nd of February also, thereafter also I cooperated. In remand also, there is no allegation that I did not cooperate with the investigation. But no antecedents. There are no antecedents. So maximum punishment is 5 years. That I failed to point out, but maximum punishment, page 18, that is 5. Adjudication, I'm sorry. In my compilation, page 9, page 18. Shall be punishable, clause 1. The clause 2 and 3, lesser punishment. If the amount is less than 5 crores, bailable, and punishment is less. 3 years, 1 year, maximum is 5. Case is Now based, since it is going on since 2000. Case now essentially rests on documentary and electronic evidence which is in their possession. Question of hamper temper would not arise. Since 2 years, I have not influenced any witness. It is not their case that in 2 years I have done any overt act. There is no allegation of any overt act on my part. So why I would do now after being released on bail? So trial will take a long time. Given the pendency of cases before the Chief Judicial Magistrate, trial is to take a long time. And only on the ground, my lord, in economic offense, my lords are aware, Sanjay Chandra, etc. That if the trial is to P. Chidambaram, etc., if the trial is to take a long time, where maximum punishment is up to 7 years, that itself is a consideration to enlarge one on bail. Notice under 41 as CRPC is not issued. Since 2022 till 2024, summonses were issued. I cooperated in the summons. Notice under 41 as CRPC was never issued. It is mandatory as per the Ernest Kumar and as per Satyendra Kumar guidelines. Only on the ground, I point out, page number 32 may please be seen of the compilation. I have highlighted the first para itself. Code of Criminal Procedure, section 41A, courts will have to satisfy themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail. Investigating agency and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and the directions issued in Ernest Kumar versus State of BR reported in so and so. Any deviation on their part has to be brought to the notice of the higher authorities by the court, followed by appropriate action. State governments and UT to facilitate standing orders for the procedure to be followed. Page 33 may please be seen. Applicable even for economic offense. Bail, economic offense, gravity of the offense, the object of the special act and attending circumstance are few factors to be taken note of along with the period of sentence. After all, an economic offense cannot be classified as such as it may involve various activities and may differ from one case to another. It is not advisable on the part of the court to categorize all the offenses. Please have a look at page 37. Court has categorically stated suggestions of learned ASG which we have adopted have categorized the separate set of offences as economic, not covered under special acts. This we have suffice to say on submission of Mr. So-and-so that this court in Sanjay Chandra versus so-and-so has observed in para 39 that in determining whether to grant bail, both aspects have to be taken into account. Seriousness of the charge and severity. Now this is relevant. Thus, it is not as if economic offences are completely taken out of the opposite guidelines, but do form a different nature of offence. The seriousness of charge has to be taken into account, but simultaneously the severity of the punishment imposed by statute would also be affected. The guidelines are very much there. Page 82 and 83. Some conclusion of the Honorable Supreme Court. Honorable Supreme Court says, leave apart merits. Only on the ground that there is non-compliance of 41 and 41A would entitle the accused for grant of bail. This is what I was trying to point out, page 84. This is under service tax, but the provisions are perimeter. Before making arrest under service tax, department must adjudicate demand and also grant hearing to assessee as to materials collected. However, in case of habitual, arrest may be made straight away, but subject to review of past conduct and only after recording prima facie view as to how assessee is habitual. So without adjudication, no arrest. Only in case of habitual tax evaders. This judgment is confirmed by the Honorable Supreme Court at page 124. Please see page 124. One para order, if I may read. The issue is as to whether the power of arrest under section 91 of Finance Act can be exercised without following the procedure as set out in section 73A subsection 3 and subsection 4 of the said act. The High Court has decided after detailed discussion that it is mandatory to follow the procedure contained in section 73 and 74 before going ahead with arrest of a person under section 90 and 91. We are in agreement with the opposite conclusion and see no reason to deviate. Accordingly, these appeals are dismissed. Page 127 directly on CST by the Supreme Court. Matter is still pending. Identical arguments are made. Counsel for petitioner submits that indisputably assessment has not been completed by the department so far, in which case invoking section 132 of CGSTF does not arise. He further submits that even if alleged liability of 19 crores is, as is assumed by the department, is accepted, it is open for the petitioner to file appeal after the assessment order is passed. And as per statutory stipulation, such appeal could be filed upon deposit of only 10% of the disputed liability. In that event, the deposit may not exceed 2 crores, which the petitioner is willing to deposit within 1 week and without prejudice to rights. Thereafter, Honorable Supreme Court says, issue notice on condition that petitioner shall deposit 2 crore to the credit of C number so and so within 10 days. Now, last week, please be seated. Last para. For a period of 1 week, no coercive action be taken against the petitioner in connection with alleged offence. An interim protection will continue upon production of receipt in the registry about the deposit made with the department within 1 week from today until the disposal of the special leave petition. The case of the Supreme Court is also the same argument that without adjudication, how can there be arrest? In any case, the petitioner says, I am ready to deposit 10%. The Supreme Court observes, Honorable Supreme Court observes, if you deposit 10%, we will protect you. Now, here, my lord, I have paid 10%, I have paid. Security bond of 1 crore 20 lakh is given. The total comes to 25%. So please have a look at my challans again for a moment. Page 167. This is the challan of 40 lakh, which I paid pursuant to the direction of Honorable Gujarat High Court. Please have a look at page 170. This I paid at the time of search. Please see the date, 28th April 2022, when my premises were searched. So this 2 lakh and 8,000 I paid at the time of search. Page 172 again, there is one more challan. 21 lakh 67,751. So in total, as against 7 crore 45 lakhs, the allegation is 7 crore 45 lakhs. As against 77.5 crore, I have paid 63 lakh 76,000. And bond of 1 crore 20 lakh 13,238. Approximately this comes to 25%. I had, if there had been any adjudication, I would have obtained stay by paying only 10%. Here I have paid 63 crores, 63 lakh and bond of 120, around 25% is paid. So I am on a better footing because I am here asking for regular bail. I am not here asking for anticipatory bail. As I pointed out, 41 and 41 as CRPC, that the guidelines have not been followed. I am ready to abide by all the conditions. Whatever conditions my lord may impose, including not to leave the city of Jamnagar, Lord, I have movable and immovable properties here. My family is here since last 25 years. I am here. Few judgments I may not read, Lord. Only no judgments are binding in case of bail, I understand. But only for the sake of my satisfaction, I may point out. Page 127, my lords have already seen. Page 130 and 131. Identical. Honorable Supreme Court grants protection, no coercive step. Page 132 onwards, may please be seen. These are by the Honorable Gujarat High Court and all are before charge sheet. So no judgment I have placed where Honorable High Court has granted bail after completion of investigation. So page 133 may please be seen. Same allegation. 52 days are over. Maximum is 5 years. Facing charge under 132 1C. Such Sanjay Chandra is followed and the accused is enlarged on bail. So page 137. Para 4. The same is the same observation that if I have availed ineligible input tax credit, department can always rectify and recover. But where is the question of arrest? Page 140. There, page 141 may please be seen. There the Honorable Court had erroneously stated 9 crores and investigation is concluded and charge sheet is filed. But that it was corrected at page 145. Not 9 crores, but 94 crores. Investigation is still in motion and charge sheet is not yet. At page So it was corrected thereafter. Page 146, this is a recent order by the Honorable Gujarat High Court. The accused there was facing charges under 132(1)B also. B is more serious, that I am issuing only invoice. 132(1)B, 132(1)C, and 132(1)L. Para 3 onwards, I have highlighted. The submission on behalf of the accused. Page 4, para 4 is submission on behalf of the prosecution. The amount was 67.72 crores. No amount was paid here, and this was also before charge sheet. The arrest was done in Jamnagar only in this case. Please have a look at page 151. Calcutta High Court LGW Industries. There 152. This is the complete answer to the case of the department. This is the complete answer. If I may read, section 16 of the CGST Act, input tax credit. The petitioner challenged the impugned notices whereby the respondent refused to grant the benefit of ITC on purchase from the suppliers and also asking to pay penalty and interest. Respondents alleged that the suppliers from whom the petitioners are claiming to have purchased the goods are all fake and non-existent. Further, the registration of the suppliers in question has already been cancelled with retrospective effect, covering the transactions period in question. The petitioners contended that transactions are genuine and valid by relying upon all the supporting relevant documents and have verified genuineness and identity of suppliers, and more particularly the names of those suppliers as registered taxable person were available at the government portal. The petitioner relied on various decisions in the matter, held that the Honorable High Court disposed the petition by remanding these cases to the respondents to consider afresh the cases of the petitioner on the issue of their entitlement of benefit of ITC by considering the documents which the petitioner want to rely. Now this is very important, because if it is found upon that all the purchases and transactions are genuine and supported by valid documents and transactions were made before the cancellation of registration, then petitioner shall be given the benefit of input tax credit in question. The cases shall be disposed so and so within 8 weeks. So same argument. The purchases from in these LGW industries, the suppliers were fake and non-existing. The argument was when I made purchases, they were existing. Here also the same argument. When I made purchases, all the 6 vendors were active. Their registration was cancelled subsequently. The Honorable Calcutta High Court says, if at the time of purchases, the registration is active, and if I have documents to show that my transactions are genuine, then even civil liability cannot be fastened. Here I am facing a criminal case. Well, this is a case wherein even civil liability cannot be fastened. I understand if I have floated funds by giving money to poor and underprivileged people, that is a scam, that I understand. Here, the case is those 6 people have done something wrong, but I am facing that. I have paid 40 lakhs, I have given bank guarantee, I have paid additional 20. Remaining judgments I have shown, the release order and the challans. So, what submission here is that there is no adjudication, everything proceeds on the reasons to suspect. Since there is no adjudication, I cannot file appeal, I cannot pay 10% or 10 stay, I cannot go for compounding. There may be a good case under section 16 subsection 2 clause C, but there is no case under 132 subsection 1 clause C. Additionally, I am in custody since last 26 days. A young person of 25 years recently joined his business, father's business, not even married yet. Paid 63 lakh, security of 1 crore 20 lakh, almost 25% is paid. Ready to abide by all the conditions. In these circumstances, my respectful submission would be this bail may kindly be considered for regular bail. And so far as the reply affidavit is concerned, it contains allegation against me. Not a single whisper as to why my custody is now recovered. Everything is recovered, discovered. Adjudication they have to do. Since last 2 years, they have not done anything. I have not influenced anyone till today. Now, why my remand was granted for 2 days? My statements are recorded. Why my further custody is required? Nothing is stated on the affidavit. Okay, coming to the next matter, 269, which is of the father, my lord. There also I have tendered one short compilation of 16 pages. Page 5. Here also, vehicle was intercepted from Om Banna only. Page 5, relevant portion at page 6, para 4. Then page 7. My vehicle was released, subject to payment of 40 lakhs and bond of 1 crore 17 lakh. Please have a look at page 9. The challan I have paid 40 lakh. Thereafter page 12. 11 is the release order. Relevant portion is at page 12. There I am proprietor of Volt Metal. Proprietor of the purchasing party Volt Metal has submitted DRC 3 of 40 lakhs. I'm sorry, bond of 1 crore 20 lakh. Goods are released. And thereafter the page 30. Additionally 10 lakh is paid. 10 at the time of search. 10 lakh 68,022. And page 15 and 16. My properties are attached. The first property, location, district, Jamnagar, Taluka, Jamnagar, village, Hichada. These properties attached by the revenue belonging to the present accused. And page 16. District, Jamnagar, Lalpur Road, revenue survey number so and so. So far as this accused of CRMA 269 is concerned, but I have paid, their allegation is 6 crore 67, 6 crore 67, like lesser allegation. I have paid around 50 lakhs. There is a bond of 1 crore 20 lakhs. Around 26% I have paid. There 25, here 26. And apart from that, 2 properties are also attached. So, in my respectful submission, around 50% of the dues are already secured without there being any adjudication. The adjudication is the despite that this amount is paid and the property, 2 properties are with them. And here the date of arrest is different. He was arrested on 12th of February. The first accused son was arrested on 2nd February. At that time, the present applicant was out of station. Summonses were issued to him. He took adjournment twice. One on the ground that he was at Bombay, and on the second ground for health reason he took adjournment. And on 12th, he remained present on his own. In the reply affidavit, they have stated that I was absconding. I was not absconding. They issued summons. Twice I took adjournments, and on 12th I remained present on my own, and thereafter they arrested. So there is no case of that I was absent. So with these submissions, I only submit to kindly consider both these appeals, subject to what my learned friend is.
એમાં સાહેબ અધિકારી લેવા છે ને જે આજે ડોક્યુમેન્ટ એનું જે બધું લીખી રજૂ થઈ ગયા તેનો અભ્યાસ એ બાકી છે હમણાં આફ્ટર
These are judgments.
The GST officers have produced certain documents.
नहीं, they are saying કે મેં જે આજે
એમણે compilation છે.
સાહેબ બીજા મારે છે ને આ જે GST ના અધિકારી આવ્યો ને એ ડોક્યુમેન્ટ લઈને આવ્યા છે એટલે તેનો પણ અભ્યાસ કરવાનો છે. એટલે તે ફાઇલ એની જોવાની.
You should have stated in the morning. I would have gone back to Ahmedabad. After conclusion of argument, this is improper on the part of the prosecution. Before I had started my argument, you could have said.
I think
Tomorrow, day after tomorrow, I have fixed matters before the Honorable Gujarat High Court. I would request for Monday or Tuesday. Tuesday would be fine. only for his submission and my rejoinder.
Yeah, so fifth,
Please, 5th March will be fine.
5.
I look like, we must be careful.
I am.
Like, sorry to say, but their investigation is never ending. So even after charge sheet પછી પણ સાહેબ, they say that investigation is still going. For each and every argument, if they want to give a counter, this is never ending.
શું છે?
પિસ્તાલીસ 15 માં સાહેબ સાક્ષી ને
હા?
પુરાવો વિસ્તાર કરે.
કઈ 45, 15?
45 15 માં સાહેબ આરોપી છોડ્યા આજે.
હા, એમાં સાક્ષી સવારે નહોતા. પગાર કરી દો.
આ એનું કઈ સાક્ષી
ઉમાનસિંહ ચનુભા, એમાં સાક્ષી પગાર કરી દો.
ના એમાં અરજી
311 ની છાપ બની હતી ને, ડિસ્કાર્ડ કરવાની એ નથી આપી.
બીજા કોણ સાક્ષી બોલાવો.
ચાલો, તારીખ આપી દો. 18, 19.
ગમે
19 ચાલશે. 19
સાક્ષી નું નામ પછી
19 આવ્યા કુમારજી.
આ બધા હાજર
3. ચાલો હવે સ્મિત. હવે ચાલો એ વિરાટ પેલા લેવાની છે જુબાની જોડાયા નથી. ચાલો તો.
બરાબર.
હમ
કુમારજી ધનુભા વગેરે. હા, 19 જાઓ 19.
આખો દિવસ બેસાડો પછી જાઓ. આમાં આઈએ પીઠોડિયામાં બજી જાય નહીં.
કઈ વિષય?
હમ
ના નથી.
ચાલો તમારું શું?
હા સર બોલો
ઓર્ડર ઉપર લીધી.
હા લઈ લીધી અમે.
એમાં એવી કબૂલ કરવા માટે.
કેમ અર્પિતાને કબૂલ નહીં કર્યું?
હા એ સાહેબ કે મને કઈ કઈને સૂચના કાલ ઉપર રખાવો.
તો ભલે ને તમે આવીને કરાવી દેજો. મૂકી દો. તારીખ સાઈડ પર મૂકી દેજો. તારીખ નાખીએ છે એમ.
હા કાલ
બોલો.
કેપેસિટી 3 માં 11 પર એમાં એક મુદત પ્રોગ્રામ છે અને ડેબેજ બેઠું છે જેને રિપેર કર્યું ને એને બોલાવવા હતા અમારે એ લગ્ન પ્રસંગમાં રોકાણ બાકી પુરાવા લેવાઈ ગયો છે ડેમેજ વાળી જેને રિપેર કરી ગાડી એને બોલાવવા છે
3.
15
બોલો બીજો કોઈ?
જોઈન કરાવ દીપકભાઈને કે
પછી
નહીં થાય. તારીખ જ નાખી દો ને. 13, 14 તારીખ જ આપી દો. તો ખ્યાલ બહાર જ જતો રહ્યો છે. 21 નાખી દો.
21 બરાબર. 21
21
થઈ જશે.
બોલો. બે ત્રણ